Welcome to today's video. I'm Richard Chapo. I'm an attorney down in San Diego, California, and I've been advising online businesses for 20 plus years. Today we're looking at a topic that causes a lot of confusion online for website and app owners, and it's website disclaimers explained. So when you're online, you undoubtedly see disclaimers right and left. And the question that really comes up with these is, what do they do? What purpose do they serve? Are they effective? And if they're not effective, are there ways to make them effective? So let's just start off with a simple question. What is a website disclaimer? And it is usually a paragraph of text that's used to limit the scope of something being offered, a product, a service, or information, or maybe perhaps to define those subjects in a particular way. So let's just do one now. Let's do one for this video. We'll do a legal disclaimer. Although this video addresses legal topics, it is not meant to be specific advice for your legal situation. The purpose of this video is educational only. You should consult with a licensed attorney in your jurisdiction should you have any questions or need legal assistance with the preparation of a website disclaimer. So what do we do there? We just basically said you can use this information for general educational purposes, but you shouldn't use it specifically to create a disclaimer on your website. So we'll be talking about examples for instance, and you shouldn't use those directly on your website. Every website really needs custom disclaimers. Using general disclaimers is no longer bueno. And the problem is courts won't enforce them. They're looking for something that's going to be specific to the product, service, or information you're offering, or they're just not going to force users to comply with those disclaimers. And as we'll discuss later, they may not require users to be bound by those disclaimers anyways. So let's talk about disclaimer examples. In some cases, disclaimers are actually legally required. So we have the field of weight loss products. The FTC is charged in the United States with preventing deceptive marketing practices online. Well, if you have a weight loss product, let's say you have a magic pill from Brazil or something of that sort, and you have a person up on the website, a before and after picture, and it shows how they lost 45 pounds taking the pill in 1 week. Well, that's very difficult to believe because people typically don't lose that amount of weight unless, your pill is made of crystal meth and that person was taking it full on for a week. A more reasonable example would be a weight loss of 1 to 2 pounds a week. So the FTC is going to require you to include a disclaimer that says, that weight loss is an unusual result, a unique result, and that a typical result would be whatever it would be, 1 to 2 pounds a week is the default position. But if you have objective scientific testing that indicates a higher number, then you can use that. Now, again, it has to be objective, it has to be scientific, and it has to be from an accredited institution. Your neighbor says that, it'll lose 5 pounds a week. That's not going to be sufficient. So if you have weight loss products, it's very important to talk to an attorney because that is an area where the FTC goes fishing a lot and they catch a lot of fish. You have to be very careful about the claims that are made there because, frankly, there's so much abuse. There really is. It's just incredible. Some of the things companies will say, and we're talking large companies as well. Skechers makes shoes, and you may remember they had the shoes with the rounded bottoms, and they promoted the shoes not so much as weight loss, but that they would tone up your legs. They would do magical things for your legs, and I think they had Joe Montana as a spokesman. And so the idea was because of the rounded bottom, it forced your legs to essentially muscle up a bit, to keep your balance and things of that sort. Well, there was no actual scientific basis for making those statements. They just came up with them, apparently, allegedly, as marketing slogans and a marketing pitch. And so they got pounded by the FTC. They were fined a significant amount of money, I believe, and they also had to return all the purchase prices to customers who had purchased the shoes. So it was a boondoggle. So anyways, you need to be careful in that area. Other areas where we'll see it, health information. With health information, if you're talking about anything or offering a service or a product that's in any way potentially health related, you need a disclaimer stating that, the information is educational purposes, not being offered as a diagnosis of a specific medical condition, and that the person should consult with their physician, before starting any kind of exercise plan or something of that sort. So how do we see that on sites? Well, a lot of times we'll see it just added as a basic clause. Doesn't have much of effect, but people will do it. On other sites, we actually see the concept taken into the actual content creation effort. And the site that's famous for this is WebMD. WebMD, either their attorneys or somebody there, is very concerned about potentially being sued. So nearly every health issue that they review, they always seem to emphasize the worst possible result. So if you go on there and you look up that little bump on your elbow that itches, by the time you finish reading the article, you're fairly convinced you're going to turn into a zombie in 30 minutes. They emphasize the worst possible outcome because they don't want to be sued. They don't want somebody to come back and say, hey, that bump on my elbow, it turned me into a zombie. And you said, in 99% of cases, it's nothing. Well, I was the 1% of the cases, and, I ate my family, and that's your fault. So that's why you see that. Another area where this doesn't get the play that it should, disclaimers, is in opinions of visitors. So if you have a website where you allow users to interact with each other, you may want to include a disclaimer that says the opinions of members and users of this website are the opinions of those individuals. They are not endorsed by this website. And this is particularly true if you have a site where people get into it. I mean, if you started a forum on politics, given the status of politics in this country, you're going to want that disclaimer front and center because you can be guaranteed there's going to be a lot of screaming and yelling and, insults traded and people suggesting, other people are intimate with camels and things of that sort. It's going to be a, highly, highly charged website. So using a disclaimer in that area would be smart. Now, again, there are other areas where you're going to need disclaimers. It really depends on your specific site and what you're doing. There is no one general disclaimer that's going to protect you from everything. So let's take an example. Dating sites, off the top of my head. So with the dating site, what are the issues going to be that are different from other sites? Well, how about when people meet each other? So you and I start talking on a dating site, we hit it off, and we decide to meet for the first time off the website. And, you're updating your 15-year-old picture, and, I'm trying to lose weight to look like my 12-year-old picture and what have you. But we decide to meet somewhere. Well, where should we meet? Well, if you're the owner of that dating website, you probably want to have a disclaimer that would probably be more of a community guideline, even stating that, we recommend that the first time that you meet somebody else on the site and the real world, it should be in a well-lit public place where there are a lot of people. You shouldn't meet in a dark alley. Dating sites have this problem. Fortunately, it's very rare, but there can be some bad people on those sites, horrible people. And there have been, cases where Match.com was sued, eHarmony was sued, where two people met, and it turned out the guy was completely psychotic and, stabbed the woman 50 times or something like that. And that's, just a horror situation. So, trying to emphasize to your members on a dating site that, they should go slow and keep things in a very public area, it's probably a smart move, not only legally, but just practically. I mean, you don't want to get the reputation as the site where, all the psychos reside, because that's not going to do well for your bottom line. So again, think about your site, think about, the specific things that you're offering, and, how you would want to limit those, those offerings. Okay. So all that's great and everything else, but, are the disclaimers effective? Are they binding on your users? And the answer is, if you look at the web now, most disclaimers are not. They're not binding on users, but there is a solution for it. So let's start with there are really two aspects of this. Let's start with the first one. Is the disclaimer fair? If a court feels it's inequitable, meaning unfair, they're just not going to enforce it. And, the determination of an equitable standard is really in the eyes of the court. Now, there can be elements for what is fair and not fair, depending on the state court that you're in. But I can just tell you from 20 years of history of being in court that a judge is going to make that determination on what they think is fair and not fair, and then they'll fit it to the elements. So if I have a weight loss pill claim, and I say, that you're going to lose 1 to 2 pounds a week, and there are no side effects, and then I have a disclaimer somewhere buried in the terms and conditions that says side effects may include, liver falls out of body, and in fact, the liver falls out of somebody's body, and they sue me. Well, the court's not going to look at that disclaimer as being particularly fair. Based on its location, based on, I'm trying to get out of some kind of major liability. If you're creating an unsafe environment for consumers, no disclaimer in the world is going to save you. Also, and this is very important, if you're committing a crime, no disclaimer is going to save you. You can't include a disclaimer, website owner may murder members. That's just not going to happen. It's not going to fly, unfortunately, sometimes. But that, again, another subject. So it needs to be fair, it needs to be reasonable. Don't get too one-sided with them. And then the second issue is more of a technical one. And to understand it, we need to talk about terms and conditions. So let's go back to the year 2000. The internet is a commercial medium now. It's still kind of in its infancy, and there's a lot of confusion, particularly in the legal side. Cases are being brought in front of judges. The judges are all 50 or 60 years old, and they can't work their DVD player at home, much less figure out how to work the internet. And so the question becomes, well, how does a website bind users to terms and conditions? How do you make them effective? And the argument is made to the court, well, as long as they have notice, it should be enough. And the courts tend to agree, and the rule becomes, as long as notice is there, you're okay. And so what is notice? Well, notice is just putting a link in the footer of a website that says terms and conditions, and that link then goes to another page where you have the terms and conditions listed. Now fast forward about 10 or 15 years, and you have judges sitting on the bench who have grown up with the internet now. They've had time to use it. They use it all the time. They use their smartphones. They use their computer, all these different things. And arguments are made to the courts that, hey, that approach where you go down to the bottom and you have a link that links to the terms, that's useless. Nobody does that. That approach is called a browse-wrap agreement, by the way. And the judges, because they use the internet now, they realize that's true. And so they say, we're no longer going to say that users of a website are bound by the terms and conditions where there's only a browse-wrap agreement. And before you get outraged, you should realize that that's a very equitable decision, a very fair decision. Frankly, it's the right decision. Because when was the last time you went onto a website, scrolled down to the bottom, and clicked the terms and conditions link? Have you ever done it? I'm an attorney. I don't do it. It's just not a viable means, for delivering that document and those legal requirements. So what courts have now said is that you need an approach where you can show that the customer or the user has affirmatively agreed to those terms. And we see it in what's called a check the box approach. So you go to websites, and many websites still don't do this. It's kind of amazing. But you go to websites and you'll see that you have to check a box that says, yes, I agree to the terms and conditions and privacy policy for this website. And that act of checking the box is called a click. And thus you would be stunned to learn that this approach is called a Clickwrap Agreement. Well, courts will enforce this. This is how you bind users to your terms and conditions and your privacy policy. Because at this point, the user is affirmatively clicking a box. They're saying, I agree to be bound by these terms. I agree to be bound by these legal documents and the language within them. And if the user is not reading those documents, which, let's be honest, we all know they're not, that's on them. It's not on the site. And so click wraps are enforced. Okay, what does any of this have to do with disclaimers? Well, if you put a disclaimer on the page, a disclaimer is essentially, in many ways, a modification to a contract. It's a modification to what's being offered to the user. So how do you bind the users to that modification? Well, we can't just publish it up on the site or in the footer because that's a browse-wrap agreement at best. And we know that courts aren't going to enforce that. So instead, we need to somehow get it into the Clickwrap Agreement. There are two approaches that are used. One of the approaches that I tend to like is with the checkbox statement. You would add disclaimers. So you would have the little checkbox and say, yes, I agree to the terms and conditions, privacy policy, and disclaimer. And then when they check the box, they are affirmatively agreeing to the disclaimer, which means they acknowledge it, and they're going to, be bound by it. Now, from a legal perspective, that is outstanding. I will do my victory dance around the desk. I would love you as a client. From a business perspective, maybe not so hot. The problem that we see is that when you do that, after a while, you can only add so many different things to that statement before the customer starts going, what the hell am I agreeing to? Why are there all these disclaimers? What's wrong with this product or this service? Why do they have all these things? It suggests that there's, a lack of credibility in what you're offering, and your abandonment rates in your carts can go up through the roof. That's obviously bad. So my suggestion, or not my suggestion, but what you see with a lot of websites is I'll start with this approach and kind of see what happens. And if the abandonment rate doesn't go up, they continue with it. And if the abandonment rate does go up, then they abandon it, ironically, pun intended. And so if they abandon it, then what? Well, one of the other approaches you'll see some attorneys use online is they'll put the disclaimers, they'll add the disclaimers to the terms and conditions. So they still keep them up on the website. So that people will actually see them, but they add them to the terms and conditions. And then the argument is when somebody clicks to accept the terms and conditions, to be bound by the terms and conditions, because the disclaimer is within the terms and conditions, they're also bound by that. How effective is that? Still kind of up in the air. Technically, it is very effective from a legal perspective, but you get back to that first prong of what is fair. And if you're trying to make an argument to a judge that because the disclaimer is in the terms and conditions, it should still be effective. It's still fair. A lot of judges have a problem with that, because if you have a weight loss pill and you say, guaranteed to be safe, safely lose weight for, safely lose 10 pounds over 2 weeks. Okay, well, possibly, you're not way out there on a limb as far as the weight loss. But then if you have a disclaimer in the terms and conditions down in paragraph 33 that says weight loss disclaimer, losing, 10 pounds in 2 weeks is not typical. More realistic weight loss is 1 to 2, and the product is safe, except that your liver may fall out. And in fact, one of the user's livers falls out and they sue you. Is a court going to bind them to that disclaimer in paragraph 33 of your terms? I wouldn't want to be trying to defend that. It's going to be difficult because, again, there's a fairness element to this. So that kind of gives you kind of an idea of how that works. So website disclaimers, should you have them? Yes, absolutely. Are they effective? Sometimes. You really need to think through the process of, how do you bind users to them? And the more sketchy the effort to bind the users, the more you're relying on burying them in paragraph 33 of your terms, the more reasonable the disclaimer needs to be. So if you're setting something extreme, and then burying it in your terms, court's not going to enforce that. I mean, maybe you get lucky and you get a grouchy judge who hates everybody, but it's pretty unlikely. Judges are always going to apply some common sense aspect to these situations, and so it can really end up backfiring. But there's also the added element of all of this, which is that website disclaimers are often prophylactic in nature, regardless of whether they're binding or not. If you see them up on the site, people may consider them binding regardless. They may say, well, they did warn me that my liver might fall out. And so you may be okay in that sense. And they certainly don't hurt as long as they're written correctly. So that's it for today's subject, website disclaimers explained. If you have any questions or comments, you can reach me at my website, SoCalInternetLawyer.com. Please don't post any specific questions or information regarding your website or app down in the comments below because of attorney-client privilege issues. You may not want the public seeing those comments. Feel free to subscribe to this channel. We'll be publishing videos on internet law and online businesses for the foreseeable future. And hopefully we'll see you on the rest of us. So have a good one, and we'll see you on the next video.